in a room full of people who are interested in these issues, because people who are interested in these issues tend to self-select. I'm here to welcome you. My name is Joanne Engelbert, and I am the coordinator of local Amnesty International group number 662, which meets here at this fellowship. And we welcome you to our fellowship, and we congratulate you on coming out for a night that is going to be full of information and hopefully inspiration. This is the biggest coalition we've ever been able to put together in one meeting, and this is happening all over the state. There are many meetings like this going on, more all the time. And so on behalf of death row inmates, their families, the legal professionals who represent them, and the volunteers and professionals who are working constantly for change, thank you so much for coming together tonight. There will be a table downstairs with a number of actions you can take, petitions and all postcards and all sorts of things. Please look for that. And particularly I would like to welcome one very special guest, who is Ron White, our most recent exoneree. Ron? And now my job is to get out of the way and introduce to you Nancy O'Byrne, who, along with Christine, is the one who really made this happen tonight. It's a pleasure to work with Nancy because she has two important connections. First of all, she is the organizer of Compassion in Action St. Augustine, which has been working on issues like this for quite a long time. And also, she is now president of the board of Floridians for Alternatives to the Death Penalty, which is doing really super important work to work for the abolition of the death penalty. Nancy?
All right. Thank you so much for being here. It's important, and it gives us so much support and an uplift to see this many people interested in this topic, because it is a life and death topic, isn't it? I have the honor of introducing our esteemed panel tonight. Unfortunately, Mark Elliott, the executive director of Floridians for Alternatives to the Death Penalty, could not be with us. He was going to be our fourth panelist. He called me last night, and he is just not feeling well at all. He decided that drive from Tampa to here was going to be a little too much for him. I do want to say a word about Mark, though. I've never met anyone more dedicated, more passionate, more civil and logical about abolishing the death penalty than he. He became executive director of FADPA, which is kind of short for that long name, about 12 years ago, on a solely volunteer basis. And he is still working on a solely volunteer basis. He has brought together this nonprofit organization to where it is today. It's the collaborative statewide entity that works behind the scenes to bring together the many various and diverse stakeholders in Florida for our struggle to abolish this broken death penalty system. And I'm privileged to be on the board of that organization. Before I introduce the members of our panel, I do want to welcome Jim Purdy, the public defender for the 7th Judicial Circuit. Would you stand up, please, Jim?
Attorneys from my office.
Please introduce them.
Felony Division Chair, my Division Chief for St. Augustine and for Putnam County, Norma Wynn.
Great.
Definitely attorneys in the office who does Flagler County now. Definitely attorney in rising up in the office for St. Johns County.
Thank you so much. The 7th Judicial Circuit covers St. John's, Flagler, Putnam, and Volusia counties, by the way, so that's a lot of territory to cover. So thanks again for coming. All right. Our first panelist tonight is Stephen Harper. He's the Executive Director of the Florida Center for Capital Representation. Mr. Harper is a clinical professor at Florida International University, at the College of Law there, where he teaches a course on death penalty and serves as the supervising attorney in the College of Law's new death penalty clinic. For 29 years, he worked at the Miami-Dade Public Defender's Office, serving the last 17 as coordinator of the Capital Litigation Unit, where he was primarily responsible for the gathering and presentation of mitigation evidence in capital cases. From 1989 to 1995, Mr. Harper served as the chief of the Juvenile Division. In 2002, he took a 2-year leave of absence to coordinate the Juvenile Death Penalty Initiative. Mr. Harper has lectured nationally and internationally on both juvenile and death penalty issues. He worked on the American Bar Association's Guidelines Advisory Committee and participated in the revision of the ABA guidelines for the appointment and performance of defense counsel in death penalty cases. Next, we're going to hear from our guest of honor, Ron Wright, Jr., the most recent exoneree, number 27 in Florida and number 159 in the United States. Mr. Wright was convicted in 2014 and acquitted in 2017. I believe, however, he spent 7 or 8 years incarcerated, and he'll tell you more about that. The U.S. Supreme Court ruled that the purely circumstantial evidence against him was insufficient to convict him. A majority of the court joined a concurring opinion by Justice Charles Kennedy, holding that no rational trier of fact could have found beyond a reasonable doubt that Mr. Wright was the killer. The court noted that none of the evidence presented at trial directly tied Mr. Wright to the murders, and that the victim's young adult daughter, who had a volatile relationship with the victim, also had a financial motive, having received more than $500,000 in life insurance benefits as a result of her mother's and half-brother's deaths. Mr. Wright was convicted and sentenced to death after a bare 7-5 majority jury vote. The Florida Supreme Court has since declared death sentences based upon non-unanimous jury recommendations are unconstitutional. Finally. We are happy that that happened. And Christine Henderson is our third panelist. She's the national organizer for Equal Justice USA. Ms. Henderson has an extensive history of working with communities and youth to improve the juvenile justice system at all levels. She has worked throughout Florida, in Jackson, Mississippi, and a variety of other communities in the Southeast to further advocacy and litigation efforts with Southern Poverty Law Center. She was often called upon to build coalitions, mobilize citizens, provide community action plans, and train advocates to lobby for themselves and their communities. Ms. Henderson was instrumental in helping build the case against an abusive juvenile justice facility in Mississippi, which was ultimately closed, and she worked tirelessly to maintain pressure on decision makers to maintain certain standards of juvenile care during a proposed legislative overhaul of the juvenile justice system. She currently focuses much of her organizing in Jacksonville, Tampa, St. Petersburg, and Miami, as these are the 4 worst counties, not only in Florida, but nationally, in usage of the death penalty. Christine is also on our FADPA board, and her energy, enthusiasm, and organizational skills are unmatched. Just so you know, there will be time for Q&A after the panelists present. And please don't go home without signing our Take Action petitions downstairs. We've got postcards already written out. All you need to do is sign your name and print your address. So please, we'll tell you a little bit more about the actions later. And now, Mr. Stephen Harper.
Thank you. Can you,
Would you like to use the lectern?
Do you want to use the lectern?
can I use the lectern?
Sure.
Well, okay, it's okay with you.
I'd have to rearrange the camera.
No.
Sorry. So sorry.
All right, well, I can sit. I can sit.
Use the mic, please, so folks can hear you.
Okay. Have to do two hands.
It's a good thing, actually.
Can you go up?
Back one.
Yeah, keep going. Let's go. There you go. I guess my job tonight is to. Can everybody hear me? I don't need them. Okay, good. I'm used to trying. Many times I talked in court, and the judge would say louder, louder. So I've learned to speak loudly. As a lawyer, it's a pleasure to be here. We litigate, and we fight, and we do all this stuff, but we really don't know how what we do is received by the public, or is it? Do they know what's going on? Do they care what's going on? And it's great to see you here, because while lawyers do lawyer stuff, you are the difference. People that are out there lobbying their representatives, lobbying their senators, following the polls, you will be the ultimate people that change the way that Florida treats people who are subject to the death penalty. Hopefully, you will get rid of the death penalty. So it's a pleasure to be here to talk with you. I'm supposed to talk about specifically Hearst. Hearst was a case where I say, oops, because it took the U.S. Supreme Court 14 years to understand and to recognize the fact that jurors make all the factual decisions in a case. There was a case called Ring versus Arizona, and in that case, the court ruled that judges can't make factual decisions. Only jurors can make determinations of fact. That's our constitutional right. And so, Ring versus Arizona, they changed the statute, and it would no longer, a judge could no longer make the factual determinations. In Florida, lawyers, I'm sure, like these public defenders and I, we would go to court all the time and say, Judge, you can't make this decision. You're making factual determinations independent of the jury. You can't do that. Ring versus Arizona, the judge would say, well, if I'm wrong, the Supreme Court of the United States will tell me I'm wrong. And that's what the Florida Supreme Court said for 14 years. And then finally, in Hearst, the U.S. Supreme Court took it, and they took the issue up, and they basically decided, based on an 8-1 decision, that the Sixth Amendment, the right to a jury trial, prohibits the judge from making any factual determinations. So Ring versus Arizona, every factual decision in a capital case must be made by a jury and not a judge. And facts that make somebody eligible for the death penalty also have to be found by a jury. Okay, so Hearst stands for the proposition that about 150 people who are already on Florida's death row will have a resentencing. I noticed when I came that we're going to get into this a little bit, but it's complicated. It's a whole other lecture. It's a whole other discussion. But there were about 400 people on Florida's death row, and some of them who had a 7-5 jury recommendation are not going to get any relief at all because their case was finished prior to Ring versus Arizona coming out. That's horrible. So it's the luck of the draw. If you happen to have some legal issue that's still going and your case is not completely finished, you are in the running. If your case was over and it's finality, you lose, and that's a horrible thing. And it's the Florida Supreme Court drew a line and it's a false line, I think, but they drew a line basically saying, if your case was alive after Ring, you will get relief. There are a couple exceptions to that we'll talk about. But if your case was finished before Ring, you get no relief. And that's terrible. But I also look at the fact that 150 people prior to Hearst who were not going to get any relief now have an opportunity to relitigate their claims. So that's the good news. There's bad news and there's good news. So Hearst was decided in 2015, and they basically said there's a Sixth Amendment right to a jury trial. Facts that increase in punishment, it's an element that must be submitted to the jury. And Florida law did not require a jury to make the critical findings necessary to impose death. So you have 7 to 5 jurors. 5 jurors would say, I don't think this person should die. And the judge would never overrule that jury and just say, well, I think the aggravators outweigh the mitigators independently, give them my analysis, and I'm going to sentence him to death. It was crazy. And we were all saying, this is wrong. This violates Ring. But judges told us, wait. And finally we got what we needed, which was Hearst. Now then, after Hearst, a year after Hearst versus Florida came out, there was a second opinion called Hearst versus State. And that's a Florida Supreme Court decision. And the court held that juries must unanimously find all of the facts necessary to impose a death penalty. That includes the existence of any aggravating factor, for example, heinous, atrocious, and cruel, or cold, calculated, premeditated, relied upon as a reason to impose the death penalty, and those elements have to be proven beyond a reasonable doubt. They have to also determine whether the aggravating factors in and of themselves provide sufficient grounds for imposing the death penalty. And finally, whether the aggravating factors outweigh the mitigating circumstances, which is what mitigating means reasons why not to kill the person. For example, he's horribly abused as a child. That's a mitigating factor. They have to weigh the aggravating factors with the mitigating factors. And that is the holding of Hearst. So, facts. What are the facts? There's some legal dispute about this, but fortunately the Florida Supreme Court in a 4-3 decision ruled the right way. Facts include the existence of aggravating circumstances justifying death. Aggravators outweighed any mitigating circumstances, and all of this means that death is the appropriate sentence. That's what facts are. That's what the facts are. So, after Hearst came out, the legislature said, okay, we're going to change it. So they made some good changes, right? The Florida legislature said, okay, now the state must provide notice that we're seeking death within 45 days at the time the person is arraigned, meaning he enters a plea of not guilty, whatever. The arraignment is when the court notifies him officially of what he's charged with. So within 45 days of that time, they have to announce whether they're going to seek death or not. Prior to that, I had cases in Miami where 2 years into the case, the state had not filed a notice of death. They say, oh, we're going to seek the death penalty. We think this is a death case. All of a sudden, it becomes a death case, and that's just unfair to the defendant. So now, and this is getting litigated as to whether if the state does not provide notice within 45 days, are they barred from seeking the death penalty? That's going to go up to the Florida Supreme Court. It's going to get resolved by them one way or the other. They also found that a jury must determine that at least one aggravating factor exists, and it has to exist beyond a reasonable doubt for a person to be eligible for the death penalty. And the jury recommendation must be based on whether the aggravators exist, whether the aggravating factors outweigh the mitigating factors, and whether a person should be sentenced to death. And the Florida legislature, there's a prosecutor in Osceola who said, wait a minute, we can't let juries make this decision. If one juror or 2 jurors basically say, don't kill him, then the majority of the jurors doesn't get what they want, that's terrible. It's terrible. You can't trust jurors. And so the Florida legislature basically said, okay, you have to have 10 jurors, before somebody can be sentenced to death. You have to get at least 10 jurors. If you get 9 jurors, a person automatically gets life. Another case the Florida Supreme Court ruled on is Perry versus State. And in Perry, this is a really important decision. It was already mentioned, but Perry struck down the Florida legislature's revision of the state's capital sentencing statute because it did not require a unanimous jury. And that's a big one in Florida. Florida was an outlier, but now nearly every other state in the United States, about 2 or 3, require a unanimous jury recommendation before somebody can be sentenced to death. If the jury now is not unanimous, then if one juror says, I think the person should live, I don't want him to get the death penalty, and 11 jurors say, we want him to get the death penalty, he lives. Okay, and there's different reasons for that, but the Florida Supreme Court has found that to be constitutionally required under both federal constitutional law and also Florida constitutional law. That case went up to the U.S. Supreme Court. They rejected it. They did not take certiorari, meaning they didn't consider it. So that's good law now. And by all of that, we have a much better sentencing scheme in death penalty cases, because a prosecutor is going to think twice if he doesn't think he can get a unanimous jury to make to find the facts and to make the decisions to sentence somebody to death. Now, I'm just going to talk about retroactivity briefly. It's a whole big lecture. But relief only goes back to the day Ring was decided. Even if a case involved a 7-5 jury recommendation, you don't get relief if your case was final prior to that. And that's horrible. It's really horrible. They could have said, we're going to give everybody relief, and that's the end of it. Everybody on death row gets a resentencing. Or they could have basically said, everybody on death row gets life, which is what happened when Furman versus Georgia, which was the case in 1972, which temporarily got rid of the death penalty in the United States. That's what the Florida Supreme Court did. Anyway, 2 exceptions, right? Your case was litigated after Ring came out, but you waived a jury. You let the judge make the ultimate decision. You said, I don't care, I don't need a jury, I don't want a jury. Judge, you make the decision. If you did that, you're not entitled to relief. The Florida Supreme Court has ruled that you are not entitled to relief if you waive the jury. And my first reaction was, wait a minute, I can see people wanting to have a perfect case that I litigated. I held my breath, but we waived the jury because we had expert testimony which we thought was powerful and convincing, and we had a good judge, and we thought he would understand what the jury was saying, or what the expert was saying, and jurors may well have just thought, well, here's the state expert, here's the defense expert, they're both prostitutes, the heck with it, we don't care about it. However, if I had known that it would take a unanimous jury, I may well have made a different decision. If there had to be a unanimous decision. But the Florida Supreme Court has said, tough luck, you're out of luck. The other thing is if there's harmless error, right? So in other words, I love the concept, harmless error. It's kind of an oxymoron. But anyway, it's a legal concept where if at the trial court there is a mistake, there's error, it's not reversible if it's harmless, meaning a jury would nevertheless find somebody and sentence somebody beyond a reasonable doubt. In other words, that's the test. If you can say that it's harmless beyond a reasonable doubt, then it stands. And what they're saying, if you had a unanimous jury recommendation, right, prior to Ring, or after Ring rather. So you had 12 jurors, they all said, we think he should get death, that's our recommendation. Then that person is not eligible for relief. And the Florida Supreme Court, I think, has been disingenuous about this because they're supposed to look at harmless error on a case-by-case basis. Look at each case, look at all the facts of each case, and then make a decision as to whether the error was harmless. But what they're doing is any case where there's a unanimous jury recommendation as opposed to finding, they're basically saying it's harmless error. So the current Florida statute, which is a better statute, just to let you know. A jury has to find at least one aggravating factor. If they don't unanimously find one aggravating factor, the person is ineligible for death. Now, a whole other discussion, but Florida has so many aggravating factors. I challenge people to come up with a case, a first-degree murder case, where death is not a possibility, where a person is ineligible for death. It's a trick. I tried it with my students and they could never figure it out. I have a couple, but it took me a long time to figure them out. Anyway, a jury has to identify the aggravating factors, right? They have to say, we think it was cold, calculated, and premeditated. They have to be unanimous in that finding. If 11 jurors say, we think it was cold, calculated, and premeditated, another jury says, no, it wasn't. I don't think it was. It doesn't stand. It does not exist. And the jury recommendation shall be whether sufficient aggravators exist, and in determining whether aggravating factors outweigh mitigating factors, whether the defendant should be sentenced to death. So the aggravating factors can outweigh the mitigating factors, but they still have to decide whether the defendant should be sentenced to death. And again, only if the jury is unanimous in its recommendation can a person be sentenced to death. So if the jury recommends life, the sentence life, period. If they don't have a unanimous jury, life. If the unanimous jury unanimously recommends death, the sentence can be, but doesn't have to be, death. The court, at that point, can make it independently weigh the aggravators and mitigators which were unanimously found by the jury. Now, you can't go beyond what the jury found, but a court can, it's rare, but if you have a unanimous jury, a court recommendation for death, the court can nevertheless give him life, okay? I don't know, there are not going to be many courts that are going to do that, but it's still a possibility under the Florida statute. And the good thing about this is the court cannot find additional aggravating factors that the jury did not find unanimously. So where are we now? Again, the bad news is that there's still too many cases resulting in death sentences. I was really excited, euphoric, that the death penalty ground to a halt and the law changed wonderfully. Florida law now exists like most other states, and that's a good thing. But there are still too many death sentences in Florida. The good news is that of those 19 people, so far, 19 people in the state of Florida who were sentenced to death, the prosecutors said, wait a minute, this is not a death case anymore, we're going to waive death penalties. So 19 of those people who are on death row are now off of death row. So you're going to see the death row population in Florida go down from 400 down to the low 300s. That's going to happen. And other cases, it's going to get litigated. But we're going to have Hearst resentencings. The prosecutor is going to put on all its aggravation. The defense is in a much better position now because the presentation of mitigation is improved, and it's a little bit complicated, but post-conviction lawyers have found mitigation that the original trial lawyer did not find, and all of that's going to be represented to now a unanimous jury. Or have to be a unanimous jury. So there's some good news here, some really good news. So this case is reviewed so far by the Florida Supreme Court. Number of prisoners who have obtained relief under Hearst, in other words, who get a resentencing, about 128. Number of prisoners who have been denied relief under Hearst, 129. There are a total of 377 prisoners who were sentenced under the unconstitutional sentencing scheme, but only 42% prisoners who were sentenced under that scheme will be entitled to relief. So that's right. It's going to change. If these more cases go through the courts, that will change. The last thing I want to show you is circuits. Hearst resentencing still pending. And this is, I think it goes. Florida courts are divided by. There are 20 different circuits in Florida. Ask me what the Sixth Circuit is. I don't remember. But so I've sort of given you a town that helps you understand where that circuit is. Look at Jacksonville, the Fourth Circuit. 17 Hearst resentencings. Osceola, Brad King is a prosecutor. He's a very aggressive, very old-time prosecutor. He's the prosecutor that argued to the Florida legislature that you should not have a unanimous jury. You should only have a 10-2 jury. Actually, he voted for a 9-3 jury. They compromised and gave a 10-2 jury decision.
So that
But,
Ayala's cases were being
Yeah, and he also has taken on
Attorney Ayala.
Ayala's case. She's the elected prosecutor in Orlando, and he is the governor assigned him to take her death penalty cases. Daytona, you have a number of Hearst resentencing, which is hopefully you'll. What?
I think we have that many.
Well, you may not have them yourself, but that's in your jurisdiction. In other words, they're private lawyers.
We may have conflicted out of it
Yeah.
for them because they were still not yet final, and they were challenging ineffective assistance of counsel was an allegation that was still not yet resolved. And as long as that's out there,
But how many cases is your office handling, let alone not conflict counsel or not private counsel?
I don't think we have any right now.
Really?
I don't believe we have any Hearst cases right now.
Well, great, wonderful. I know that the conflict counsel has a number of them. Here's another one. Orlando is high.
Yeah.
Look, West Palm Beach is a very populated place, and there's 0 resentencings so far. Tampa has 8. Sarasota has 2. And then these are the final up to the 20s. Those are the numbers. So this is a real quick where we are today. We've had 22. Once the cases started back up again in Florida, the death penalty started back up. It was held up until the Florida legislature passed legislation requiring a unanimous jury. And so there's a backlog of cases. And so there are lots of cases that are happening. However, again, there are 19 Hearst waivers. 22 of those cases have already gone to trial, and they came back with life, or one was not guilty. I think that was yours. I don't know. 6. We've had 6 death sentences. 6 death sentences, and that's way too many. And we also have 5 death recommendations where the jury has come back 12-0 favoring death. The judge has not made the final decision, but my presumption is all 5 of those will ultimately be death sentences. And we have 6 cases right now that are pending the penalty phase, meaning they've been found guilty of the crime, but they have not yet started this penalty phase, which is whether they should live or whether they should die.
When you say 19 Hearst waivers, you're talking about the state attorney waiving the resentencing for death?
I'm sorry?
What is a Hearst waiver?
A Hearst waiver, yes. The prosecutor basically says he was on death row, but we're not going to seek death because the defense has no real control over that, right? If the prosecutor says, I'm not going to seek death, case is over. Yeah. Anyway, so that's a quick explanation of the law. Other folks can talk about more realistic things and more compelling things and more. But I will tell you that for me, it's a pleasure to be here because it's great to see this many people on a Wednesday night. At 7 o'clock? I would probably be home asleep by now. But it's wonderful, and you people will make a real difference. 2 things I just want to tell you. One is that the polling that we've done and that has been going on, even in, like, for example, what was the last poll? One was in Dade County, the other was in St. Petersburg. St. Petersburg, right. The statewide polling has found that the majority of Floridians would prefer life without the possibility of parole as opposed to the death penalty. And even in St. Petersburg and Miami-Dade, the numbers are much higher than that. So that the legislators are actually behind what the public wants or doesn't want. That's good news. The other good news is that in the United States itself, the death penalty is on the decline. It is slowly disappearing. The number of people being sentenced to death, the number of cases in which prosecutors are seeking death, the number of cases in which juries are imposing death, all of those are going down. So, notwithstanding the fact that a different justice than we had anticipated was appointed to the U.S. Supreme Court, I think that the death penalty is on its last legs, which will put me out of a job. But I'm going to take up trust and estates, by the way. If anybody wants an estate planner, call me in a couple of years. But I think that that's the good news. But the bad news is we still have to slog on. And it's going to be we're going to have to do a lot more work. But folks like you energize folks like me, and I hope that helps. We got to get more Floridians on board, legislators, people, and get them interested in this issue. That's it.
Okay, thank you. Okay,
Go ahead.
Mr. Ron-
Now the real person speaks.
Mr. Ron Wright.
My name is Ron Wright. Is this on?
It is.
I couldn't hear. As you were told earlier, oh, okay. As you were told earlier, yes, I was convicted of a capital crime and sentenced to death. Last July, concluded 8.5 years of that ordeal, and I came home. First of all, I had no idea that these organizations existed. And for those of you that don't know, I was a police officer. I did over 20 years in the United States Air Force, reserve and active duty, as a law enforcement and counterterrorist operator. The 3 years that I spent on death row, I want to say thank you if any of you participated in some of the cards and birthday cards and letters we got, because I kept asking, where is this from? Who are they? How do I write? And no one had a clue. So I got to see that quite often up there, and I think that made a lot of guys' days up there, and it was very well received, and a lot of them are very grateful for it. So thank you for that, and thank you, of course, for your efforts in fighting this death penalty. I think my case is probably the one that sticks out in everybody's mind right now, being so recent, as probably the poster child for abolishing the death penalty, because, well, you can't convict and execute an innocent man. That was something that the Florida Supreme Court pointed out, and I didn't go back to retrial. It was remanded back by the Supreme Court with directions to enter the acquittal. So it took all 7 justices unanimously to decide that there was absolutely no way I should ever have been accused or charged, much less tried and convicted, not to mention sentenced to death. It's hard for me to kind of get into the prosecutors' minds and share with you what they were trying to do, other than win. That's really what it boiled down to. I learned something throughout those 4 weeks of trial, and that is that the trial is not about the truth. The trial is about which of those two sides has the better story to convince 12 people to vote their way.
Wow.
I can't tell you how many times my attorney had to strap my butt to that seat that I wanted to come out of it screaming, "That's not true. Who is that? Where did that?" I sat there for almost 2.5, 3 weeks wondering, when are we going to get to the part about me? I haven't heard my name yet. Then there was the matter of certain pieces of evidence that, well, I'll give you one good example. There was one item that we wanted to do DNA testing on it. At the pretrial hearing, where we're asking to hire this DNA expert to do this, you know, the prosecutor gets to argue against that. The man actually said on the record in court, "Your Honor, I don't know why the defense wants to test an item that has already excluded the defendant." That same article they turned around at trial and relied on to say it was me. I pointed that out to my appellate attorney, and she couldn't believe that the trial judge, it's, you know, I don't know. So I think over that 4 weeks of trial, I got a whole nother insight to this whole criminal justice thing. it kind of opened my eyes and my understanding in other ways that as a police officer on the street, I would have never seen or known. My job on the street is to look for trouble. That's what we do. If we don't go look for them, we don't get the schedule and, who will be committing what crimes and when we need to respond. We either look for it to stop it or we respond after it occurs. On this side of this process, I got to see what goes on in the courtroom. To sit in that defendant's seat and hear all those things said and basically have this picture of you painted like that, it's gut-wrenching. The worst of it is there isn't a thing you can do about it. One of the deputies that escorted me back over to the jail, their jail and courthouse is one huge building. You just walk through the back tunnels to get over there. And walking me back, he said something that I really hadn't thought about. What he told me was, I know you can see what's going on here because we all see it. Well, wait a minute now, I was right there. Well, what did I miss? What did you see? What are you talking about? He says, well, basically, man, you read what's in the papers and that's one thing, but when you're right here looking at it, listening firsthand, he says, frankly speaking, it's their story. They get to tell it the way they want to. And two things that members of a jury, you all as jurors potentially will never know, is that what those prosecutors are telling you is not the truth. The second thing jurors will never know, they don't know what the truth is. That is something that I doubt ever crosses a juror's mind. But at the same time, I got this one analogy where, how did he explain it to me? When the jurors come into the courtroom, they see two different tables. One table is the prosecutors, and there's this huge box. Something too big for Santa Claus to get around with, okay? A nice big box with the lid on it. They look at the other table, well, that's the defense table. There's a small stack of folders with some papers in it. Now, every time the prosecutor wants to present another piece of evidence or another witness or something else to the jury, they go back to that huge box. So what the juror's seeing is, my God, he must have done it. Look at that, they got all this stuff. He must be. You look at the defense table, yeah, he's done, he's cooked. Stick a fork in him, Perception is what I'm getting at here. What those jurors and everybody else in that courtroom doesn't know, as big as that box is, it's empty. It's an empty box. It's almost like they know they'll win at trial and it will be reversed on appeal. What difference does it make to them? I sat in pretrial confinement for 5 years before I went to trial. It took 5 years to get that thing into a courtroom. After I was convicted, I waited, I think, about another year before sentencing. I think the trial ended in February of 2013. I wasn't sentenced until August of 2014. And then the Supreme Court reversed in May of last year, and they basically told me, you ain't got to go home, but you can't stay here, and sent home in July. But one of the things that I wanted to impress upon you all is that the bulk of the problems, I think, with the death penalty come from either bad law or bad prosecutorial acts in that courtroom. Especially in cases of, what's evidence? Does anybody know how any item becomes a piece of evidence? What determines that this is evidence in a case or crime? Does anybody have any idea? Have you seen The Matrix, the computer program?
I watched Law and Order.
Did you see the big chart that they use when they hold the conference and everybody, takes a vote? Did you see? Did anybody see how the determination is made that that is evidence?
No.
Here's the answer. It's a human being that decides that's evidence in this case. That's all it takes. A detective, a crime scene analyst, a technician, there's a cigarette butt, an empty beer can, whatever it is. That's how the determination is made that something is evidence in a case. It is collected, processed, and whatever becomes of it from there, but that's how the determination is made. There's no system, there's no program. All it has to do is be found or discovered, and a decision is made to use it. The reason I'm going through this is the way prosecutors use evidence in that courtroom during a trial. And it's not the fact that it's evidence, it's how that evidence is presented to the jury. And like I said, this is why the jury doesn't know. It's their story. They can tell it the way they want to. And by the way, and please correct me if I'm wrong, has anyone heard of any law, any statute, any rule, any process or procedure that says anything or everything that the prosecutor states must be truth? Is there any requirement for that? Has anyone heard of any such thing?
Should be under the code of ethics.
Exactly. Does the American Bar Association have such a requirement? There is absolutely nothing that requires what the prosecutors tell that jury to be a matter of fact, a statement of fact, or truth. This is why it is put in the hands of the jury to decide what is or is not truth. But before you get to do that, this is where the prosecutors get to make sure you see it their way. It's their story, they get to tell it the way they want to. This is what contributes to a lot of bad convictions. This is also why we see so many exonerations. These are cases that should never have been inside a courtroom. These are defendants that should never have been charged, tried, much less accused. There was one other thing, I just lost my train of thought on it. What usually works better for me, I know you all know I've pretty much been through the whole process. Questions. I get a lot of questions about things, and I usually do better answering your questions than I do trying to figure out what you want to hear. Yes?
Did you waive your right to a speedy trial? Why did it take 5 years?
I'd have to ask one of the attorneys that, because I don't remember waiving anything or anybody.
Well, I would just say is that
Could we, please, I'm sorry.
I'm sorry.
It's making it very difficult for the person who's doing the taping here. Could we have the questions at the end?
Oh, at the
All
end?
the questions?
Oh, okay.
Yeah, and then we can have a really good discussion because it'll be all set up. I
Oh, I
thank
see.
you. I'm so sorry to interrupt your train of thoughts.
Hearst.
Buy one as well, and you bring it there.
As far as the Hearst decision goes, now on death row, there's 17 cells in a row. You got guys on both sides of you unless you're on one of the ends. The day the Hearst ruling came out, I can't tell you how many people went running around hollering, ain't gonna be nobody on death row no more. They thought that within about 6 to 8 months, we'd all be long gone. The problem with Hearst was nobody understood it. All they knew was all we heard was what we heard on Capitol Update, which is Hearst got, he got a new sentencing. I don't think everybody really understood why. It wasn't until later that we found out about the 2002 cutoff date. And I'll give you my perspective on that. If the highest court in the land can determine that we have effectively bad law, anybody who was sentenced under a bad law should deserve the benefit of having that error corrected. It should not matter when the error occurred or whether it was harmless or not. The problem was that the error occurred because of bad law. We've now corrected that part, but do we just arbitrarily decide that some do, some don't, some get it, some don't get it, some will, some won't? Me personally, I would like to see everybody get the benefit of a new sentencing under good law.
Yes.
And then at that point, if nothing else, at least we can at least look back and say, we did it right and we did everything we could. Because who knows what comes out of this later on? Perhaps new evidence comes to light, something else winds up being discovered, and before you know it, it's not just about the sentencing. Maybe we find out that guilt was not so much a foreclosed issue. Maybe by now, we need a whole new trial because guilt is now called into question. I'll share this one thing with you. It had to be after 5 years that I think everything really kind of sunk in with me. And this is after, I got recalled to active duty after 9/11. I wound up on the ground in Kuwait. Next thing you know, they're talking about going into Iraq. And I said, I don't know nobody over there. I don't need to go. My family's back in the States, and they didn't care. But after going through all this stuff, it took the first day of jury selection for things to really hit home with me and really ring my bell, so to speak. That happened when one of those first 60 potential jurors, it was that first phase where the judge is trying to pretty much give everybody an opportunity to want to get out of it. One woman stood up. Her reason for wanting to be excused was because where she lived previously, I think somewhere up in the New England area, she was a juror on a homicide case. They did vote to convict this individual. They voted for death, and he was executed. And it wasn't long after his execution, the guilty party was discovered and confessed to it. Imagine sitting in that chair and hearing that and thinking, whoa, you mean this really happened? Come on, hey, I've heard of it, I've seen it on TV, but I ain't on TV right now, that rude awakening kind of really, got my stomach to do a couple cartwheels for me. Thinking back to that day really made me stop and think. We say we have the best legal system in the world, but I think what a lot of people forget is it's not the system, it's the people who orchestrate, who administer, and in some cases manipulate the system. Of the two major errors in my case was the error on the part of the trial court. That's the judge. The judge denied my motion for a judgment of acquittal, which in the Supreme Court's opinion is exactly what they reversed. One of my trial attorneys told me what a big issue it was over in that area when, 3 of the justices that are known to be big conservatives? Yeah. I think Kennedy and Holston, and now the newest one. Justice Kennedy wrote a concurring opinion. In my case was what they call a wholly circumstantial case. If you're not familiar with that, that means there's really no evidence against the guy. It's just circumstances that make it look like it might have been him, but we don't know, okay? In a circumstantial case, there's a special standard of review that applies to circumstantial cases. Justice Kennedy wrote this concurring opinion saying that even without the special standard of review, he felt that no finder of fact could have found all elements of the crime beyond a reasonable doubt under the general standard of review that otherwise applies to every case. This is something, I think I was told those two prosecutors were the well-seasoned, I think, longest tenured veterans in that office. Those are the two ones that they're at the top of the list. They've been there the longest. It was a little comforting to find out. I think shortly before I was sentenced, I found out that another case that they handled out of Pasco County had just been reversed as well. I forget the name of the guy, but they're kind of getting a little bit of a black eye over there, so to speak. If y'all don't know, that's where the Casey Anthony jury came from, and there was all kinds of discussion about that over there. Now, my case gets reversed. So I think there's more to be said over there. I don't know if it's the way that office works, if it's the way the judges like to, I don't know, operate from the bench, or if it's really what the people in that community want. What I'm hearing is these polls are showing this is not what the people want. Unfortunately, we need more people and more voices. One of the other things I think we need is to start taking a hard look at just what really is behind this desire for the death penalty. In my opinion, we have it and somebody wants it used. It's just a matter of punishment. They want it used. I hear this word closure all the time. And again, this is my opinion. It doesn't exist. The only way to truly give closure to anybody, at least for me, give me back what was taken from me. And that we don't have the power to do. You want to punish somebody? That's why we built that jail, that prison. A life sentence, if so deserved, so be it. But a death sentence, we can't undo that. It's one thing bad enough we can't give time back. Why go even further to take the risk of doing something that we can't undo? I personally feel like if we're not going to do it right, why do it at all? What's the point? So what I'd like to see happen now with this Hearst ruling, everyone should deserve the benefit, and the attorneys can correct me if I'm wrong here, of a true due process and going back to a resentencing under good law. After that, we need to stop sending more cases into these courtrooms and then into these appellate courts because of the errors being committed during the trial phase. If you're not familiar with Aramis Ayala, the elected prosecutor over in Osceola County, I watched the oral arguments where it looked to me like it was a big battle between the governor's authority to tell her, you have to use the death penalty, and basically the will of the people who cast their votes for her to say, we don't want to use the death penalty. I don't think the governor should have the power or the authority to override the will of the people when their vote has been cast and their voice is spoken. I was kind of hoping when I saw this group of conservative or Republican attorneys or prosecutors, I forget which group they were, but they were supposedly conservative Republicans, come out in support of her. Unfortunately, that's like the first step. The toes are being tickled and we need to get the next foot moving. So hopefully we can continue to move this process forward. We can continue to open some eyes and get some ears to bend toward us. And if nothing else, never give up. You never know when that one decision, that one meeting, or that one phone call may just be all it took to make all the difference in the world. Thank you.
Thank you.
Thanks, Ron. Good evening, everyone. Once again, my name is Christine Henderson. I'm an organizer with Equal Justice USA. Equal Justice USA is a nonprofit organization that focuses primarily on ending the use of the death penalty. They have been a part of campaigns that have ended the use of the death penalty in several states up north, 7 states, and I'm here in the South. So we have a journey, but I have faith. I always have faith that we will end the death penalty here in the state of Florida. And I just want to thank everyone here. There's something that's so important about advocacy. There's something that's so important about standing up and doing the right thing when you know the wrong thing. is being used as a mechanism to continue a process that's unfair. And when I'm talking to groups in the community, when I'm talking to organizations like Amnesty that get it and understand, I just want to take a minute and just thank you. Because you help my work as an advocate, as an organizer. It's a difficult thing to fight against the death penalty in the state of Florida.
Yes, again.
But there has been a lot of progress because of advocacy. And that's why it's so important to get involved when you see things are wrong, policies that are wrong, laws that are wrong. We're looking at what's happening with Hearst. How can we stand here and allow for a system to draw a line in the sand and say, we screwed all of you, but we're just gonna give you, this half of you, the opportunity for a second chance or a second opportunity. And, well, good luck for those that don't fall in line, fall under that circumstance. And it's not right. It's important for us as Floridians, as residents, to use our voice and say, what are you doing? When we were going back and forth with the Hearst decision and, and they were saying, hey, this is unconstitutional, and our legislators decide to go in the back room and say, well, we don't really want to do unanimous. We'll just say 10-2 and see where it takes us. So with that process, another year goes on, and, people are just illegally being sentenced to death. And it was allowed. But then the process kind of found itself and was like, wait a minute. No, this is wrong. And you have to. But it was a lot of attention, a lot of noise that was happening in the state that kept this conversation going, right? Yes. When you have Jacksonville, 54 faith leaders across denominations, across faith, joined together, signed a letter and demanding that Angela Corey stop the use of the death penalty, yes, because they are tired of being one of the top worst counties on a national and state level, that shook the tide. Angela Corey's gone. When Duval County shook it up, Tampa reached out to Equal Justice and said, hey, I know you guys are working with faith leaders in Jacksonville. We're already working against the death penalty in Tampa. We don't like to be one of these bad outlier counties either. Can you work with us? Can you support us so that we can continue this, so we can do what Jacksonville did? We want to let our prosecutor know we don't like this behavior. So we go to Tampa and St. Petersburg because I know Nancy mentioned this before, but they're on a national level. There are 16 counties on a national level with the oath for use of the death penalty. Florida has 4. That is our Jacksonville, our Tampa, our St. Petersburg, and our Miami, Florida. So when Tampa reached out, and the neighboring county, obviously, we're Floridians, so we should all know that there's a bridge that pretty much separates Tampa from St. Pete. The faith leaders in St. Petersburg were like, we want to work together on this. We don't like to be one of the top 4 either. So right after Jacksonville had the faith leaders come out and stand up against it, shortly after, St. Petersburg and Tampa faith leaders joined together, and there were 75 faith leaders across both counties to come out and say, we don't like being the top of the worst. And we want our state attorneys to stop the use of the death penalty. And they themselves had a press conference and hand-delivered those letters to their prosecutors. What makes a difference is when the voices of the people are heard. The pressure, voices of the community, victim family members. Darlene Farah, Jacksonville, was getting a lot of attention because Angela Corey was publicly fighting a mother who lost her child, who was saying, I don't want you to kill the man, the young boy that killed my daughter. It's not gonna heal me. It's not gonna make me feel any better. And how am I gonna get that so-called closure that everyone is seeking and looking for? When you consistently drag me to court over and over and over again so that I can hear the stories and see the pictures, and that was not what she wanted. But because it wasn't what she wanted, it was a public fight because because the prosecutors wanted that. How can we stand for a system where when it benefits the prosecution, right? Or it benefits our legislators, right? Our folks, our grass tops, to say, oh, we're all for the victims. We need the death penalty because the victims need this. This is how they get peace. This is how they get closure. This is how they get resolved. Explain to me how this is resolved when our families are dragged years and years. Because once a case is found, they could be found guilty and they're given the death penalty, there's something called appeal. They have a right to that. Over and over, these families are dragged into court. Over and over and over, they have to endure what they're enduring. How is that fair? Justice should be fair and swift. The death penalty is neither. And I think that's something we have to start to really consider when we always dangle the victims. This is for the victims. Unfortunately, Juanita Perez is a murder victim family member who has her story is just so powerful. She could not make it today. And we have a small little 2-minute clip of a message that she wanted to send. But her case is very interesting because she's a part of kind of this Hearst, resentencing drama that we're dealing with right now. The interesting thing about Juanita Perez, the story, is she's actually someone who's against the death penalty. That even though she was going through a situation where she had a triple murder, she lost her son's fiance, and a grandchild, she still stood against the death penalty. She didn't want it. And for her, it was that closure. It was that, let's just, I want life, so we can move on with our lives. She tells a story about her family, the division, right? Often people forget. That doesn't mean that everyone in your family agrees that you may not want the death penalty. What that causes in terms of trauma and division. And she told the prosecutor, I do not want this. Please, let's just go for life. Don't do this to my family. But for them, triple murder, this is a high-profile case. We got to seek the death penalty. And she had to ride that wave. Often when there were executions, we have pictures of Juanita outside, with signs, do not execute. But even though she was going through that turmoil and those issues in her own personal life, she was still out there fighting and advocating against the death penalty. Unfortunately, the young man that did take the life of, her family, he did receive the death penalty. Wasn't a unanimous jury. So the same woman who at the beginning in the front of the door said, I don't want it, it's not going to help me. But the prosecutors were like, high profile, we gotta do this. She technically, in their eyes, she got what she needed. Death, justice. Now, with all this legal drama and all these legal issues that happen in Florida, she is now someone that has to relive this again. Because his case is coming back to the county. And all she got was a phone call saying, hey, we're doing this again. And she was broken. I had a conversation with her and she said, they took my closure away from me when she got that call. We have to understand that we as a community cannot continue to be manipulated by talking points. Suzanne from Miami, amazing story. Father was a pastor. She herself survived. Her dad unfortunately did not. It was an attack. She watched her father take his last breath as she lay on the ground and she pretended to be, Suzanne Boston, yes. She pretended to be, yes. So you guys know Suzanne's story. Some of you have heard her story. But to hear that she had to be on the, she was on the stand and she was warned not to say that she doesn't support the death penalty. On the stand as she's trying to defend and fight to save the life of the young man who almost took her life but took her father's. And on that stand, when they asked her, what is it that you do? And she's like, well, I'm an advocate, and they were kind of asking, what do you do? What kind of advocacy? Gets the death penalty. Stop the court. The jury was put out. She was threatened that she would be held in contempt because she let the jury know that she didn't support the death penalty. I find that this is very strange because she was the victim. But yet she's told, do not let the jurors know that you don't support that. Why? Because that might go in the favor of the defense. That might go in the favor of helping to not take a person's life. That's interesting. And I wanted to share Juanita's story, and we tried so hard to get her here, and she tried. It's just, she just was dealing with a lot. Because it's so important to understand that and I can't stand or sit here and say that everyone feels the way that some of the families that we are fortunate to work with here in the state who are against the death penalty. But usually, from the work that we've done, that initial pain, that anger, that hate, when you lose someone, it's real. And no one is saying that it's not. You have every right to feel that way. You have that. Darlene, when I spoke to her, she told me, I wanted to kill him myself. He took my baby, my daughter. You have to understand that pain and that guilt. But after a while, the family members who initially were like, I want that justice, I'm angry, they realize, this isn't helping. They're not coming back. I still have to think of them. I still have to miss them. I still have to cry over them. This does not change anything. And now I have to go to court, and I have to deal with this for years and years. And a lot of times, these families that have been drugged back and forth to court over appeals, usually those death sentences that they were chasing for so many years end up becoming life sentences anyway. And it's like, how much drama, how much pain, how much trauma, actually I was trying to say trauma, are we are we going to allow our state to inflict on families? What can we be doing that's better? About $1 million a case, chasing a death case? Chasing, no guarantee, chasing. When these families could use services, when you lose a loved one, the division, the children that need counseling or services, the family members that go through mental health issues because of these problems, we're not funding those, but we're funding the $1 million it may take to chase a case with no guarantee that you're going to even receive the death sentence. But the morality of it. What kind of society are we when we stand there and we say, let's take a life to teach someone not to take a life? Right. Here. And because this is just the most disgusting thing that I can think, we are obligated to fight for those whose voices are not being heard. And when we participate in actions, and you participate in writing a letter to a senator or legislator, or thank you because you voted this way, it's so important. The last day of the session, there was a 33-3 vote. First vote, public vote on the death penalty in the state of Florida, bipartisan in the Senate floor. Now, it was the last day, we didn't have anything in the House, but let's just focus on the positives here. That was it. It was the intent that 33 senators voted that it's not fair what's going on with Hearst. It should be retroactive. That is a step in the right direction. And immediately when this happened, Equal Justice and FADP got together and said, we have to show these representatives, these senators, that when they step out and they take that chance, knowing that they'll be targeted and this will be used against them down the line, we as the community, we as their constituents, have to give them permission. Thank you for that vote. You represent me. And so we immediately sent out actions to our folks and said, hey, here are the 33 senators. please send out and just tell them thank you, because we're probably going to need them again next year as we continue this fight with the death penalty. I don't want to take too much time because I know that we have some actions.
You want to show Juanita's?
Yes. We'll go ahead and share the 2-minute video with Juanita. But I just want to also say that within the work that we're doing, we bring folks like Ron, exonerees from death row. We have family members like Juanita and Suzanne and Darlene that are willing to come to your churches, your community meetings. You want to put on an event, let us know. Reach out to us. Nancy, we're well connected. Joanne, she can connect with us, and we'll get them there. We'll take care of it. We'll get them out there. You don't have to worry about cost, because it's about awareness and it's about getting involved. And so please, please, please don't forget that we're here not just for support, but we can also help to get those voices of the people that you need to get out there as well. Thank you.
Thank you. Thank you.
Attorney's offices. But when you are in it and you're stuck in it, in this death penalty that goes on, and there's no closure, you have to wonder, how good is this policy? How good is the death penalty? Because it's not stopping people from killing people. I want other families that don't want to deal with the resentencing to speak up with me. Let me know that I'm not the only one. Let's put our voices together. Let's fight against this. Who wants to go through this again? It's devastating. Let's get together.
I'd just like to say one thing. The lawyers, being lawyers, can only do so much. So we got about 150 people, actually less than that, who are eligible for Hearst relief. That's great. But you are the people that can get the other people who don't get Hearst relief. So the lawyers can only go so far, and the courts are only going to go so far. But you can get the people and the law changed so we go all the way and get rid of the death penalty.
Okay, we're going to open up for questions now. So just raise your hand, and Joanne has a mic. She'll bring it to you.
Yes, and when we go downstairs, you're cordially invited to come downstairs for a wine and cheese reception, and please don't leave without signing the petitions. I just want a big hand for this group. Special thanks to Nancy and to Christine for organizing, getting it together. Who has a question?
Would the panelists use the microphone that's on the
Sure.
table there?
My question, I suppose, for you is it just for resentencing, or do they have to go through the whole trial again?
No.
And then, could I leave one more question on the table? Is that I would like to know, I want to hear a question, looking at my names, the gentleman in the middle, what you're doing now.
Well, is this working? Can you hear me?
Yep.
The Hearst only goes to resentencing. It does not go to the guilt or innocence. That's an issue that's already been decided. There's been no problem with that decision. But the Hearst resentencing, because, among other reasons, the sentence was not unanimous, it has to be they have to get a brand new sentencing. It only pertains to that.
And then what is Ron doing now?
What's Ron doing now?
What are you doing now?
Second question for Ron.
I'm playing the lottery and digging for nothing. No, I have left military service. We did the change of, or going through the process to correct the record. Believe it or not, the Air Force decided not to wait for me to go lose at trial. They went ahead and gave me an other than honorable discharge before I went to trial. So what we have to do now that everything's been reversed is we're in the process of correcting the record and going ahead and allowing me to retire. And I'm driving a truck, so I get to travel under other circumstances now.
God. I can't believe they did that before you went to trial. Impossible.
Yeah, I think it was like 2 years before.
Well, first of all, thank you, Mr. Wright, for taking the time out to come here tonight and enlighten us with all the problems you have. My question is, were you happy with your representation, your attorney's representation?
I will say this. I know that one of them was appointed and the other was brought in by him. And I can't thank them enough. Even though I lost at trial, the truth is they saved my life because it was the work they did in that trial that allowed my appellate attorney to do her job so easily on appeal. If you don't understand the direct review, which is what we call a direct appeal, the law in Florida states that every case where a death sentence is handed out has to be reviewed by the Florida State Supreme Court. It goes directly to them, not through any of the district courts of appeal. When that happens, excuse me, when that happens, you're appointed a public defender. Mine was out of the 10th Circuit over in Bartow, and it is basically a review process where the Supreme Court says, we looked at everything looks good, they'll affirm it. Or, we got problems, we reverse and send it back. Well, this is one of those cases where had the trial lawyers not done their job like they did in this case, who knows what the outcome would have been or how much harder a job my appellate attorney would have had. So yes, I can't be grateful enough because, as I say, they saved my life.
I'd just like to say that the lawyering in death penalty cases in Florida is mixed. There are some very good lawyers who work hard to provide good representation, and there are some very bad lawyers who represent people. It shouldn't be that way when you have the most serious cases, but it's a real mixture. He was lucky to have lawyers who understood not only to make the record, but to preserve the record so that they had appellate issues that the court was going to hear. I can imagine some lawyers who handle death penalty cases not doing that. So it's a real mixed bag, and that's something that is a disgrace and also a reality.
Years ago, I went to resentencing for Stephen Booker, and that was in Gainesville, and he had admitted his crime, but it was to get off of death row. And the jury was not allowed to know that he would not be eligible for parole, although all these University of Florida grad students knew, everybody in the audience knew, and I thought that was really quite reprehensible that everybody knew, but it was a secret kept from the jury that he would never be eligible for parole. I was wondering how often the jury is left ignorant.
Well, that particular issue has finally changed. Jurors, when you say somebody is going to be sentenced to life, he's either going to be, the defendant is either going to be sentenced to death or he is going to be sentenced to life without the possibility of parole. And the jury can be informed now that he's not going to get out. There's no chance of him getting out. But there was a period of time where that happened. Yeah, our hands are tied. This is ridiculous. We can't tell them that he's not going to get out. Yeah, I mean that's the law changes correctly very slowly.
The comment was made about what began to change when you had a large group of clergy that were speaking out against this in St. Petersburg, also in Tampa. In terms of advocacy on the death penalty at this point in Florida, where is the lever? Who should that go to? What if we were to write on that, or if we were to make phone calls? Where is the best leverage in order to pry that up?
There's many different layers to that. One, I would recommend if you're in the top 4 outlier counties, top priority is to be talking and putting pressure on those legislators as well as the prosecutors, the state attorney's offices on a local level. It's very interesting. When we're talking about death penalty in Florida, there are folks who have been a part of this death penalty movement, like Nancy, for years, predated me. The death penalty movement has been 10 plus years in Florida. Never really, it's gained attention, but never had the momentum. But lately, because of all the legal stuff and all the movement with advocacy, you've seen that there's been a small change. There wasn't a belief that we could end the death penalty in Florida about 2 years ago. I think now people are a lot more skeptical that this can actually happen. But we still think that the local level is always the best pressure, right? Because when it's session time, we have a couple of months, and the legislators are trying to do the best they can to get everything that they want passed. They're trying to lobby all these people, trying to visit them every day. They give you 3 or 4 minutes to make your pitch, and then it's out the door. But when it's when we're not in the session, and you're on that local level, you're having those conversations with your legislature. When they'll meet with you for 30 to 45 minutes because they're in their neighborhood office, it's valuable. I think local pressure is the key, but I think contacting our legislators on a statewide level is also very important, because we have to get everyone to come together on the death penalty at some level, and they have to feel that their constituents are talking about the death penalty. They're concerned about the death penalty. And if they know that that's stirring up, it makes our job easier as advocates to say, hey, the community, this is what the community wants. But then they can sit there and say, you know what, I know, I got like 3-4 letters from folks that were talking about this issue, tell me some more. And they help to keep the door open to a door that usually is shut, that we often have to kick in to get in.
I would just add to that, I think that's right. She's absolutely right. The pressure should be on the politicians who are in the House and in the Senate in Florida constantly and specific to the death penalty, but you should also pressure and gather momentum to pressure your local prosecutor. If they know that there is most prosecutors are of the belief that the public elected them and wants them to seek the death penalty, and in many cases as they think they should seek it. If there's a pushback to that, and you basically say, no, we don't want you to do that, we're happy, then they get the message, one, that that's okay, and two, that they may actually lose. The pressure may go against them, that they'll back off very quickly because they're elected officials. But I would think that's a really great place also to pressure and put your pressure on.
And that's a great segue to let you know about what's downstairs waiting for you. We have a petition to the state prosecutor, one of the state prosecutors here in our circuit, downstairs for you to sign, asking them to stop seeking death penalties. We have a petition to the governor. We have a letter that you can write to your state senator and state representatives. And then we also have a letter thanking Senator Bracy and Senator Hudson for voting for this particular bill that Christine talked about to get rid of the line in the sand that they've drawn about this cutoff for who's eligible for resentencing. And then I believe Warren has brought postcards to send. You just sign them about this limitation that they want to do on visiting prisoners now in our state. So there's a lot you can do, and please don't go home without doing at least one of them, please, all right? I'm just going to take 2 more because I want time left for us to go down and do those actions.
Yes, for Ron. Ron, have you taken the time to register to vote yet? Because if you haven't.
I love it. This man is very single-minded.
You know, having been in the military for so long, I tried to stay out of the political thing, but a very good friend of mine decided he wanted to be sheriff, and I actually went down and registered to vote because I wanted to be a part of getting him on that primary. So that was a long time ago, though. But I do intend to register and to stay active in my community. And one thing I will say about these elected officials, whatever you do, please don't let the party thing get in the way of what you're trying to accomplish. It should not matter what party, it shouldn't even matter whether or not you voted for this person, because once elected, they belong to you.
Amen. Good. Okay, Ray, last question. Go ahead.
Last week, a few of us saw the video that was of Darlene Farah's her situation. It followed her family through the trials at home, etc., and two other people. One who was executed. Darlene, by the way, is the victim's mother. Her daughter was brutally killed. But the two other situations, the one was executed, one was found not guilty, as you were, Mr. Wright, and is also driving a truck. Because they did follow, they followed him, what did he do afterwards and on. He's doing quite well, amazing after all those years in prison and solitary. You'd think they'd already be too crazy to get back in the real world. But anyway, I was just wondering, I don't remember the name of it, but I'm sure Nancy does.
The penalty.
The penalty. Yeah. I was saying, if that film, if there's access to it, I think those of us in the room who belong to other groups and things, I think that's a great film to take to our clubs and things,
yeah, that documentary
to spread awareness.
Is available for anybody who's interested and wants to get an event put together to show that. That'd be great. Let me know.
And I wanted to say, Darlene was there. She was in the audience with us, and then she was on the panel, and it was for Flagler students. There were very few adults in the room, some professors, I guess. But anyway, those students who typically get up and leave while someone's still talking, sometimes that hadn't even started the Q&A, but always leave for the Q&A. Only the adults typically are left. They were there, except for a couple who did get up and leave. They stayed for the panel discussion and those Q&As.
Is anybody from Flagler here tonight?
Hey, Nancy.
That's what I thought. That's what I thought. They said they would come tonight, and they did. Thank you.
So it's well worth.
A few more that left because it is finals week.
Thank you very much for coming. Please, I thank you for coming, and please go downstairs before you leave. Thanks so much.